Thanks so much. This is the perfect time to have this debate. You have to have had your head in the sand if you haven't been thinking about privacy and surveillance lately. The great Justice Brandeis warned in a famous 1928 dissent in a Supreme Court wiretapping case that the progress of science in furnishing the government with the means of espionage is not likely to stop with wiretapping, and that the government might be able to expose the most intimate occurrences in the home. Here we're going to talk about particularly privacy in the public space, but also surveillance and communications, which I think proved Justice Brandeis right yet again in oh so many ways. Within the last 3 months, we've seen striking examples of the power of technology and massive data collection and analysis in today's world. There are examples for good and examples for bad. First, to pick two, in April, the FBI identified within only a few days 2 terrorists who expected to avoid capture by lurking in the crowd at the Boston Marathon bombing before setting off their bombs. Americans overwhelmingly approved of that success that the FBI had in locating these 2 terrorists. Then in June, through Bart Gellman and Glenn Greenwald's journalism, America learned of a previously secret NSA program called Prism that collects non-contents metadata, and we'll explain what that is, of Americans' internet communications, regardless of whether these Americans are suspected of any wrongdoing. This is very, very different than the traditional surveillance model where the government looks at the activities of suspects or investigates specific crimes. This is much more controversial. We're very fortunate to have law professors Jeff Rosen and Tim Wu, 2 of the foremost thinkers and writers on technology and privacy issues, to debate this trade-off between privacy and security with a particular focus on surveillance in public places and on the internet. So first question, and Jeff, you'll kick off, and we appreciate your doing this. The degree of public surveillance these days seems to be unprecedented. There are CCTV cameras, sensors collecting location information on smartphones and other sorts of devices, and even future surveillance by flying drones or the Internet of Things, where your dishwasher will be able to tell whether you sent them a communication and relay that back. And we may soon be at a point where all of our public movements are recorded and stored. Is this a good or bad thing? Should we have any expectations of privacy in public places? Do we need to buy what today's New York Times fashion section called stealthware to be able to evade detection?
Well, first of all, I'm delighted to be here debating my old friend Tim Wu. And I'm especially delighted to be on the pro-privacy side of this debate because, ladies and gentlemen, I am determined to convince you that, of course, we have some expectation of privacy in public places, and to the degree that Tim says otherwise, he is unconvincing. So you described some of the surveillance technologies that we're now facing. Flying drones that could track us from door to door. Soon, Google Glass will record our conversations, and we'll have to decide ahead of time whether a particular encounter is on or off the record, as well as existing camera footage from publicly and privately owned cameras and smartphones. I was at a conference at Google just a few years ago, 2007, and the head of public policy said he imagined very soon Google and Facebook will be asked to unite all of these surveillance feeds and to archive and store them and put them live online. If Google and Facebook did this, then you could zoom on a picture of anyone in the world, say me, back-click on me to see where I was coming, in this case, lunch in town, forward-click to see where I'm going after the panel, and basically have 24/7 ubiquitous surveillance of anyone at all times. Would this violate my Fourth Amendment rights against unreasonable searches and seizures of my person and electronic effects? Of course it would. How could it not? Would you be convinced if the government told you that I have no expectation of privacy and the government is free to use this camera system to track me from door to door, as Tim Wu will try to persuade you? Of course you should reject that unconvincing point of view, just as the Supreme Court did unanimously by a 9-0 vote when the Obama administration made the argument that my friend Tim Wu is going to make in this debate today. The Solicitor General of the United States stood up before the Supreme Court in the Jones GPS tracking case. Remember, that was the case that involved the government putting a global positioning system device on the bottom of the suspect's car and tracking his movements 24/7 from door to door. The Obama administration said there was no need to get a warrant before engaging in this month-long tracking because the suspect had no expectation of privacy in public. The very position that Tim Wu is going to be taking. And As a result, no warrant was required. The court rejected this 9-0, although the justices disagreed about the reasoning. 5 justices, led by Antonin Scalia, said because a physical trespass was involved, the government had to affix the GPS device to the bottom of the car, therefore a warrant was required because at the time of the framing, any physical trespass with the intent to gather information would have required a warrant. But 4 justices, led by Samuel Alito, would have gone much further. They recognized that the government could have tracked the guy's movements without physically affixing a GPS device to the bottom of his car by subpoenaing the geolocational information stored in his smartphone and in digital servers owned by Google and Yahoo and AT&T. Therefore, said Alito, the real question is, does a particular form of surveillance reveal so much about our intimate activities, the people we associate with, our political associations, the bars we visit, and so forth, that it violates our expectation of privacy? And those 4 justices said, of course it does. So we have lots to debate about the details of these programs, but I just want to remind you, if he tries to narrow the proposition here, the real question is, should there be some limitations on at least government surveillance of our public movements? And I think the answer has to be yes. The framers of the 4th Amendment would have insisted no less.
All right, well, it's
The battle's joined.
it's my turn, and it's also a pleasure to be here with my long-standing friend, Jeff Rosen, who I've seen wear many hats, but not a tinfoil one before. So this is the first time I've seen that. So I just want to make a few points. Now, one of the things that's sort of lacking from this whole discussion is that a lot of what you're referring to as surveillance is actually things that people have voluntarily gotten into. You're talking about Google and Facebook and so forth. People have evidently chosen to sign up for Facebook and tell everyone about themselves because they think that's what they want to do to maintain their friends and family relationships. People sign up for Gmail because Gmail gives this enormous free email service, which people seem to like. And so a lot of what you're talking about is actually the actions of independent citizens who have decided what to do. And you're sort of trying to impose on that and saying, these are going beyond what people should do, which is paternalistic. I think that people can choose for themselves whether or not, and you're not a paternalistic person, so I don't know why you would want to have people choose for themselves. One thing, the way I've done research for this panel is have gone to many of the parties here and sat at bars and talked to people about
Welcome to Aspen.
and talked to people about their preferences. And the only thing you can really say that is true about privacy is that people vary dramatically in what their privacy preferences are. Last night at the Pepsi party, mention one of our sponsors, very good party, there was a gentleman who shall go by the name of Rex to protect his privacy. He said to me, and I was like, we're talking about privacy. He said, I don't care if everyone knows who I sleep with, what kind of drugs I take. Why should the government be interested in that? They don't care. They can know whatever they want. I really don't care. It's not going to affect my career. I don't care. So that's sort of one extreme. He said, anyone can know anything they want. He said, I don't want my girlfriend to find it out. But this is his opinion. And there are people like that. There are other people whose position is very clearly that they don't want anything known by everyone. They want to have a very strong sphere of privacy for themselves. And I think that's right. And what I'm trying to suggest is we need a framework where Americans can choose for themselves the kind of privacy they want, as opposed to sort of a one-size-fits-all solution. We need to have bans on, have very tight bans on how much surveillance is allowed. The second big point I want to make here is to say what Jeff is sort of getting around, or he's not quite ignoring it, but what he has de-emphasized is that even today, and there has always been a division between the private and the public. In the public, the idea is that your expectation of privacy disappears dramatically. This doesn't mean you don't have privacy. It means that what we need to know is when we are in a private space and when we are in a public space. And there are enormous benefits, as we're going to argue later, to having diminished privacy in public spaces for reasons that are central to law enforcement, central to anti-terrorism efforts, central to law enforcement, particularly against criminal organizations. There needs to be this power in public spaces to have more surveillance as long as we maintain a private space as well. And what Jeffrey hasn't talked about is the fact that even though he's worried about all this public stuff, we have maintained this private space inside your house where you're free to take off your clothes and dance around or do whatever you want. I'm trying to, whatever you want, you can do in that private space. In the public space, you should understand that as a society, we have certain public demands that demand that we will have greatly diminished privacy in the public space. So that is a trade-off. The decisions you're talking about, like the tracker decision, the justices actually did say that was a violation of privacy. So the Supreme Court is in the process of trying to adjust this line between public and private at all times. So we have a system that is more or less working, so I don't see what you're complaining about.
Is
How's
the
that?
line...
Can I respond?
Sure.
Let's just make sure the issue is joined. The position you just heard is that whenever you go out in public, it is permissible for the government, not the private sector, to say, take a drone and put it on you and track you 24/7 from door to door for a month. That is the position Tim Wu has raised, and he's claimed it's paternalistic to stop you from doing that because you'll voluntarily do that because you turn over your email to Facebook. I would like to just start this debate with a constitutional vote, just a show of hands. Who agrees with Tim Wu?
Who agrees
that
the
it would
question
be
wasn't phrased
permissible?
correctly?
Who
says the question
You
wasn't
can
phrased properly?
reframe the hypothetical, but this is I want
Jeff,
to.
in fairness, I think we should draw a line here.
Well,
The
well,
line
no.
may... No, but hold on one second. The line may be between comprehensive tracking of an individual and incidental capture of information through a surveillance camera or otherwise. I mean, if you think about the London Underground, for example, after IRA terrorism in the 1970s and early 1980s, the London Underground decided to put surveillance cameras in every station. They proved to be very useful after an al-Qaeda terrorist attack in London, and the cameras are visible. It's not the sort of thing that comprehensively tracks people, but it takes photos in places where there are particular security risks. Do you agree that that's a reasonable limitation on your right to be private in public spaces?
I will answer that question as soon as I get an answer to the one that I raised, which is we're not talking about targeted surveillance, which raises other questions that I'll talk about in a moment. Tim made the claim, he said it was paternalistic to prevent any tracking, comprehensive tracking in public places for a month.
That's not exactly what I said. I said that when you have excessive rules on private companies and their collection of information, that those end up being paternalistic when Americans have very different preferences as to how much information they want to share.
Okay, well, if you don't embrace it, I want to see if anyone in the audience does, just to make sure what the parameters of debate are. Who agrees with the proposition that the government should be able to take a drone and follow you without suspicion, door to door, in all of your movements in public spaces, 24/7 for a month? Who
Your
thinks
own
that would
private
be,
drone.
I'm asking the question. Who thinks that that would be consistent with the Constitution and the Fourth Amendment? I see two hands. And who thinks it would be inconsistent with the Constitution and the Fourth Amendment? Tim?
Well, if you want to boil everything down to a specific case, I mean, this is what I think is the real problem with this debate, is once you put the case, like, for example, should we have CCTV cameras which are running but not being viewed by anybody, and then those are used to find the Boston bombers? Who thinks that was unconstitutional for that particular case to analyze that data to look for the Boston bombers? Does anyone think that was an unconstitutional use of the government's power?
Depends on where the cameras were.
Right, the cameras in the public. Cameras are in the public.
Depends on where they are.
Right, they're on the streets, and they're panning and they're collecting data all the time, which is sort of like your little drone. And so basically what you've realized, what everyone in the audience is, this is insulting the audience, but you've an inconsistent position, because you already are in that world when you're walking around and the cameras are collecting information. So it all tends to depend on what you think are the specifics of the situation. Nobody likes this idea of having data collected on them and read by a government official when they don't think anything's going on. But no one...
You guys keep saying constitutional. Are you talking about the Constitution as written, or are you talking about, say, with the overlay of the open fields doctrine?
Good question. So for those who are lawyers or recovering lawyers in the room, the question signals the fact that the Supreme Court has basically made the Constitution as currently interpreted possibly not to constrain surveillance in public. The open fields doctrine says that when I voluntarily surrender information to a third party, I assume the risk that that third party may disclose it to the government. So under this open fields doctrine, or you could call it the third party doctrine, you could argue, as the Obama administration did, that when I go out in public, I'm voluntarily abandoning expectations of privacy in my electronic geolocational information. I'm assuming the risk that the government might be tracking me, and therefore the Fourth Amendment is not violated. What I think everyone in this room said when they raised their hand is that that can't be a sane interpretation of the Fourth Amendment. And that's just what Justice Sotomayor said in the Jones case when she said we have to reconsider this doctrine because it would give us far less expectations of privacy than the framers took for granted. So I think it was a useful, look, we'll now have a debate about the details of whether short-term versus long-term surveillance is okay and public versus private cameras are okay. But I think, I'm being provocative to frame our debate. I think it's helpful that we start this with a consensus in this room, and I think from Tim as well, that ubiquitous month-long surveillance without limits and without suspicion would and should violate the Fourth Amendment.
Right. And what I'm trying to suggest is that when our answers are somewhat inconsistent because everyone put up their hands and said that they find that unconstitutional. Nonetheless, presented, for example, with the Boston bombing and the fact that we know that there's cameras on all the streets. So in fact, it's not quite a drone. A drone makes it sound a lot scarier. But there are these little cameras that are panning forth. And so you're already in that world. And then faced with an actual case where there was an actual people killed, real criminals involved, everyone's all of a sudden, well, of course, in that case, that seems completely reasonable. So it all comes down, and this is maybe where the details also, the specificity of what's going on. And so if you're walking out of your house and we have your imaginary drone, but we also know that you're the head of a criminal organization or that you are a terrorist planning an attack, and we have specific information about that, and it's the same situation, we're monitoring him to try and find out where he's going to meet his other contacts so that they'll design their plan. How many people think that would be unconstitutional to use that data? A few people. Right. With a warrant. I'm talking about it with a warrant. And I'm talking about with a warrant.
Okay.
Yeah, I'm saying with a warrant.
And,
and that's what it comes down to. It comes down to what we're talking about.
Well, if that's all we're talking about, then we have no debate. Because that Justice Scalia, in his wonderful dissent in the DNA case, Justice Kagan,
I overstated. You're right. It has to be without a warrant.
You say without, right.
Yeah. It has to be without a warrant. I'm saying without a warrant.
Yeah.
Yeah.
So then the question is, do you have to have a warrant? And that's an important debate to have. Do you have to have some, but even without a warrant, you have some degree of individualized suspicion. You're not doing mass data surveillance of anyone, you have a particular suspect. So I would say about the Boston bombing, your intuition, were the cameras public or private, is important. And in fact, they were private. It was a Lord and Taylor surveillance camera, as well as iPhone footage voluntarily submitted by citizens. And there's something far less violative of the Fourth Amendment, which after all only binds the government and not private individuals, when private footage is aggregated. But the other thing, which Tim is right to stress, is you need individualized suspicion. If you're just looking for footage over a period of 10 minutes before and after the bombing in order to solve a terrible act of terrorism, that is completely consistent with the Fourth Amendment's particularity and minimalization requirements. And then the question of whether you need a warrant or reasonable suspicion, we could debate. But so what's our disagreement right now?
Our disagreement is whether we should go to the next question or not.
Well, I think we can. There's also a question of whether that information should be aggregated, and I think we've heard agreement that in response to a specific event, a specific crime, for example, it may be appropriate to aggregate information from different sources. Do you agree with that, Jeff?
I think after a bombing, of course it's appropriate to aggregate to solve, but I disagree with your statement that the London CCTV cameras have proved remarkably effective in both deterring and detecting crime. So I was sent to London a month before the 9/11 attacks by the New York Times Magazine to try to figure out why this country had wired itself up with more surveillance cameras than any other country in the world and resembled the Truman Show, essentially. And the piece that I wrote had far more salience the week after I returned than it was when I got there. But I went to the central headquarters where all the cameras were monitored, and I asked, why were these cameras put up in response to fears of terrorism? Have they caught any terrorists? No, they haven't. What are they used for? They're used to track the license plates of every car that comes into the central city of London and charge a car tax on cars that stay for too long. What is the data about their effectiveness? The British government's own studies found no correlation between the proliferation of the cameras and the deterrence of serious crime or terrorism. It's true that they have proved useful in some important cases in detecting terrorism after the facts, but even in those cases, the cameras do not appear to have been the but-for cause of the detection. It's been police work and people boasting to their friends and so forth. So to justify a mass surveillance system on the grounds that it's going to prevent terrorism is unconvincing, and that it'll detect terrorism, there might be equally effective means of detection.
Look, obviously, the empirical question is an empirical question, and but you're talking about sort of deciding before we know in an absolute sense that we should ban these surveillance cameras and surveillance systems without without really whether we know about the empirics. But what I want to ask,
We do know about the empirics. There's a lot of data about it. There's a lot of data about it, and the public.
What I want to say is, I'm saying that the government needs some room to experiment with it, and if they got it right yet, then they need some room to try and get it right. And the fact you have one instance of some studies saying it's not working properly can't be conclusive against the whole thing. And the question is, what's wrong? And the question is, what is wrong with the trade-off we have, whereby when you're in your home, you have all the privacy you need. And I'm stressing, you have in places where you have an expectation of privacy, you have full privacy protections. And citizens can understand that they can do what they want in those zones, but when they leave those zones, it's very clear that you're in an area where you're a public citizen, and therefore you're involved in this trade-off. You allow, as a citizen, you give up to the greater good of preventing crime and other things when you leave your own home.
What's wrong is that the idea that we can only be private in our home makes no sense at all. It's completely counterintuitive at a time when all of us do not engage in our private activities in our home. We do it in our smartphones and our electronic devices. I used to write a private diary. If I was in the 18th century, I'd store it in a locked desk drawer. Now I store it on my Google account in the digital cloud. The idea that I should only have protection against my most intimate activities and thoughts and sensations and emotions, to use Justice Brandeis's terms, the very qualities that had to be centrally protected by the Fourth Amendment, when I happen to be surfing or browsing or writing at home and storing it on a protected hard drive, literally makes no sense. It means we would have far less privacy now that Justice Brandeis took.
But this takes you to a different point.
You really want to stress the home?
This stresses what we consider the home maybe needs to be different as we adjust. I mean, I agree with you that the cloud, let's say when you store stuff in the cloud, does feel most people here probably have stuff that's personal or interesting stored in a server somewhere. And so the question is, what should those be considered? Should those be considered sort of part of the home, broadly construed as sort of a file cabinet? But that's different, I think. What I reject in your position is the idea that there is no public. I mean, you seem to have turned everything into kind of the same kind of vague, the home is sort of everything and everything is kind of protected. I believe in a system we have very sharp delineations of what counts as private and very clear delineations of what is public, and you understand the compromise when you leave those boundaries.
I'm all for sharp delineations. I had never thought of this as my home. But if you want to say that this is my home and Google's cloud servers are my home, then we are not disagreeing.
It's frankly part of your body almost. So, I mean...
it has been ever since. No, now I've got the minis, so this is really...
Well.
But on the second point, am I saying that there's no... that everything in public is insulated from surveillance? I never said anything of the kind. We all agreed that in response to a particular threat or attack, or when I'm a particular subject of suspicion, it's appropriate to surveil me and track me in public. I said that ubiquitous long-term suspicionless surveillance of the kind we talked about by drones and of the kind that we're about to talk about as engaged in by the government in the Prism and Verizon surveillance program is a quintessential violation of the Fourth Amendment. But it is perfectly appropriate to engage in invasive surveillance when you're both effective and targeting at catching terrorists.
Well, let's turn to the next question. I think we've aired this one pretty well.
Actually, can I say one more thing on it? The biological point is interesting, and this is getting a little bit aside from it, but we are moving, a lot of hardware is moving to the body. I mean, obviously Google Glass, wearable stuff, implants coming. I'm waiting for the day where I implant my keys in my arm and just
get that RFID chip.
And so a lot of this stuff is actually going to move from these sort of home issues into personal, body privacy. And so the sort of discussion of what this line is going to, in the future, turn into a lot of these questions about what is me. And we haven't quite got there yet, but I'm really interested in that stuff.
Well, and this will just to support Tim on this point. This will give us a textualist peg. The Fourth Amendment says the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Once our persons and our electronic effects are literally merged, then there'll be a stronger, not a weaker case for saying that that sort of surveillance is prohibited.
A lot of people I know seem to value their smartphone more than, say, their kidney. So
I'd say it's a close call.
They can replace it.
Well, you have two kidneys, only one smartphone.
Yes.
Anyway.
Should we go to the crowd, then we'll turn to the next question.
Right.
Can you follow up with that for the open field question about sort of where that bright line is for enterprise? The kid from Twitter was saying that they have a philosophy that they try to live to about when and how they're going to share your data, but that's usually in the small type in that thing that you scroll down through and hit agree just so that you get into whatever program you're getting into, somewhere in there is something about where, because their ability, so many of these enterprises, to monetize their business enterprise is about grabbing your data and being able to model who you are and then being able to use that for advertisers. So your concept of bright line is lovely if it isn't that I don't really know at this point there hasn't been enough sunlight to disinfect which guys and in which ways all of this opportunity to get out on the net is now being used in a way that I feel comfortable with it, or versus a way that I necessarily wouldn't feel comfortable with it. And I don't really know which companies are more or less, blurring the bright line versus not.
Yeah, no, I think it's a good challenge from my point, and I think this is, frankly, a good reason to have this discussion. I think we are in an era where all the boundaries seem to be shifting, and when the Fourth Amendment was written, it was relatively clear what a home is and where its boundaries ended, and so you could support this relatively clear boundary. I don't know if I have an answer for every single question in these areas. I do believe sometimes when I believe in some instances you are definitely projecting out. If you have, for example, a blog post, you have no expectation in the blog post somehow is private, you put it on the web, everyone can read it. And on the other end, I happen to think that Justice Department disagrees with me, that people's emails, even stored on servers, is still their private stuff, still part of what I would consider their home. Something like Twitter.
Congress is probably later this year going to agree with you and change the law on that.
Yeah,
Let's hope so.
and require more than a subpoena to do this. And I think things like Twitter are new and hard cases, but I think we should just answer them one way or another. And I don't actually, now moving slightly against my earlier point, I don't think we should simply rely on the fine print version and say that's the answer to all problems. I know I said that earlier. But I don't think like clicking through things and saying, okay, I give Twitter all my information is always the clearest answer to this. I think we need an evolving idea of what exactly is home. And I would put email in there. I would exclude blogs from there, and I would have a new definition of what the home is.
If I could support that, that's an important concession, which I want to heartily endorse, because clearly the consent model, if I voluntarily choose to surrender data to a third party, I abandon all expectation of privacy in it, is precisely what's gotten us in the situation that we have no constitutionally protected privacy. So Tim has now repudiated that, and as we saw in the case of Yahoo, Yahoo tried to be like Twitter and refused to turn over information in response to both subpoenas and requests under the Patriot Act, and the FISA court said it had to turn them over anyway. So really, the government, the current legal regime is premised on the idea that once I've surrendered something for one purpose, I abandon all expectation for other purposes. Last night, talking with Justice Kagan, we were talking about Justice Brandeis, and I said in all hard questions, I asked myself, WWBD, what would Brandeis do? And I think that he would have completely repudiated the consent model and said there's a certain amount of public anonymity that all American citizens are entitled to demand, regardless of whether they voluntarily surrender data that's later aggregated by third parties and shared to the government. You can call that paternalistic, or you can call it upholding the First and Fourth Amendments, but I think it's important to say that even if you want to turn everything over and live in a totally transparent society, the constitutional ideal is that you're still protected from the government.
Well, let's turn now to the other high-profile issue, NSA capture and analysis of very large amounts of internet traffic data in particular. This program is known as Prism, although we learned today, and I recommend Bart Gellman's article in the Washington Post, which describes in detail how this program works. And it combines data with an intercept program called Upstream, which captures information flowing through undersea cables and other places in the global communications frame, and also phone record analysis, which is something that Glenn Greenwald brought to light in his articles in The Guardian. All these different activities were authorized by confidential secret court orders issued by a court called the FISA Court, the Foreign Intelligence Surveillance Act Court. And the communications companies that received these orders under the Patriot Act, Section 215, were barred from disclosing them. And we've heard now, Yahoo tried to resist. The court ruled, the FISA court ruled that they needed to comply, and that was a sort of head on a pike to say to everybody else, you need to comply with these. The NSA has, in defense of this program, revised its figures recently and asserts that this program has prevented 54 terrorist plots. Is this program worth it?
First of all, we can't evaluate whether it actually has prevented plots without those plots being disclosed. But more importantly, we cannot evaluate the constitutionality of the program without the legal memos and the secret orders justifying it being disclosed. Here is my position. Let's assume the program works, and in that sense is worth it. It's still completely unnecessary to design it in a way that arguably violates the Constitution as well as the USA Patriot Act. And if it doesn't violate the USA Patriot Act, then the Patriot Act itself would violate the Constitution. I think that on the back of a napkin, Tim and I, with not too much time, could come up with legal restrictions on foreign intelligence surveillance that would both allow the government to have access to a lot of data that no human being could ever see unless there was a degree of individualized suspicion that someone actually was a suspected spy or terrorist, that no data of innocent people was seen, that the data was destroyed if it was not connected to a guilty person, and so forth. What does this regime look like? Much like the law did before 9/11. It's the regime that the Foreign Intelligence Surveillance Act in 1978 originally envisioned when it said that the government could seize without a warrant foreign intelligence information as long as it was a specified set of records and it was linked to a suspected spy or terrorist. What the Patriot Act did is eliminate the requirement that it could only be certain kinds of records and allow the government to hoover everything, but more importantly, to seize records merely by certifying that they were relevant to a terrorism investigation, not connected to a particular spy or terrorist. That was the troubling and arguably unconstitutional expansion that President Obama opposed when he supported the SAFE Act in Congress, and that Representative Sensenbrenner, the author of Section 215 of the Patriot Act, has now repudiated, and he has called for a resurrection on these requirements of particularity that a particular terrorist suspect be present. And then furthermore, there were further expansions in the 2006 amendments to the Foreign Intelligence Surveillance Act, which allowed data to be seized if it was tangentially relevant to an overseas communication, allowing the government to hoover up a lot of domestic calls and use algorithms that they claimed ensured that Americans were not being spied on. So this is not a complicated fix. I think it's very troubling that the opinions are secret, so I reject the idea that we have to say, is it worth it? I say, if it is worth it, let's have it, but let's make it consistent with constitutional limitations.
Tim?
All right, so earlier I talked about the importance of a line between private and public, and now that's how we're handling the challenge of domestic surveillance. The NSA brings in another really important line, which is the line between what's going on domestically and what's going on internationally. Now, I agree with what's been said already, is we don't, making bold pronouncements about things we don't completely know about is difficult. But from what we can understand about PRISM, it is primarily meant to spy on foreigners. And I think it is always been the case, and will presumably always be the case, that we have a completely different set of understandings of what it means to spy on people who are not Americans or not on American soil. And the design of PRISM, and again, it's dangerous talking about something we don't completely understand, but it takes advantage of the fact that because the United States invented the internet, all of the internet data happens to come through, not all of it, but a huge amount of the world's internet data happens to come through the United States. And so it seems like, why not take advantage of that if it offers some marginal advantage? If it stops any terrorist acts, why not spy on people who are not protected by the Constitution at all? Why not do that? It doesn't, unless you really want to be nice to people, why not? And so it seems to me, as long as this program is directed at people who are not citizens and not on US soil, that we should absolutely accept it. It doesn't seem like there's anything on the other side of the equation, unless you really care about the feelings of people overseas, and that's not how the Constitution was designed.
Jeff?
Well, just to say, what's on the other side of the equation, even positing that there's a sharp line between foreigners, between non-citizens and citizens, is that in the age of the internet, it's very hard to tell who is a citizen and who is a non-citizen. When it was a telephone call, which is when the foreign intelligence laws were first written, you knew where it was coming from. Now it's hard to tell where things originate from, where it's being routed through, and exactly who is calling whom. And that's why I think it's very hard to have trust that the government's algorithms, which claim with 51% certainty to be filtering out the communications of citizens and non-citizens, gives me very little confidence. And I think that policing this line between citizens and non-citizens is going to be increasingly difficult.
But it doesn't mean you shouldn't try, is what I'm saying. And the fact that it's hard doesn't mean it's impossible. There are some communications which are, clearly on IP addresses, starting from an IP address overseas, ending another IP address overseas, clearly non-Americans, and to not spy on those when there's no constitutional issue involved seems to me a mistake, given the fact that it might, on the margins, deter terrorism, and seems to, and we don't really know. The 56, I'm not one of these people who is willing to say, obviously prevented, otherwise America would be, in flames right now. I'm not into scaremongering, but even if there's any benefit, then the program should be tolerated.
Are we in agreement, though, that as I understand limited information and so forth, but as described, currently described, and I think even the Director of National Intelligence has claimed that whatever limitations on the program were imposed by the FISA court and are not required by either Section 215 or by FISA itself, that as operated, it arguably violates the Fourth Amendment? I
don't think we know enough. I know that's cheating. So what question exactly do you want to?
Well, I'll make. I don't forget enough about you. Let's talk about me. I think, as described by the Director of National Intelligence, a program which allows the government to hoover up without limits. Well, let me describe both programs and say that both of them raise Fourth Amendment difficulties. The Verizon program allows
not just Verizon, in fairness.
Sorry, the Verizon and all of the other companies.
The phone company.
The phone company surveillance surveils the metadata of all domestic, local, and international telephone calls without a warrant. And it then allows for individual metadata to be looked at when an intelligence agent, not a FISA judge and not the Attorney General, when the intelligence agent, him or herself, certifies that it's relevant to a terrorism investigation. That seems to me, that would obviously violate the Fourth Amendment under current law if it was the content of email being seized.
Right,
and I would say that the metadata, which after all shows not only the telephone numbers but also the duration of the calls, can reveal so much more about the content than old-style pen registers could. Right. That there's a very strong case
that
that violates the Fourth Amendment.
This is your theory of the Constitution, not the Supreme Court's theory of the Constitution.
Correct. The Supreme Court has
Supreme Court is fine with pen registers. And
the Supreme Court is fine with pen registers in 1978. The Supreme Court has not begun to evaluate the constitutionality of this sort of mass data valence. And I think when I read Justice Scalia's wonderful dissent in that DNA case, when he said the core principle of the Fourth Amendment is that mass surveillance is impermissible because it does not include particularized suspicion, I'm not predicting, but I'm hopeful that a majority of the court would agree with me.
One thing that might be going on here also, which I think is interesting, is when you look at the American reaction to this, it has actually not been a great, there's been some outrage, but not this, no one's marching on, some people march, but there's not a huge march on Washington, there's not this huge thing. And you have to wonder if you believe that the Constitution reflects these sort of moments where the public examines a question very carefully. I think that there is some possibility that the consensus emerging is that things like metadata, non-particularized information that doesn't feel like really listening to what people are saying, people maybe feel okay with that as long as it is mostly foreigners or done in this, with some of the safeguards. And so maybe the Supreme Court will pick up from that sort of public acceptance of what's been going on and say, maybe we think about things a little differently now.
It's true the Fourth Amendment does require a judgment about reasonableness, and reasonableness reflects norms. But it is not true that the public is indifferent to mass national security surveillance. What was the one example of a case where the public rose up in outrage against a surveillance technology? This was the choice between the naked machine and the blob machine. And I love this story because it just shows what the future of surveillance may be. So right after 9/11, the government's presented with two screening technologies. The naked machine that shows contraband and plastics under your body, but also those graphic, creepy skeletal images of the naked body. And the blob machine, which has the friendly sort of avatar with a baseball cap and a little thing that points to the place in your body that needs secondary screening. You'd think, given this choice between two screening technologies, both equally effective, one is a privacy Chernobyl and the other protects privacy and security at the same time, that the government would choose the blob machine. In fact, both the Bush and Obama administration chose the naked machine over the blob machine. And it took a political protest, namely that immortal cry by the Patrick Henry of the anti-body scanner movement, that guy who at the airport so memorably exclaimed, "Don't touch my junk."
Right.
That guy created a mass protest, and then the Obama administration went back to the drawing board, and they were shocked to discover they could, in fact, retrofit all of the naked machines as blob machines. And I'm now pleased to report that most of the naked machines have been shunted off to distant airports. I hope they're still not left at Aspen. There may be a few here. But in the big cities, we now have blob machines and not naked machines. That for me just sums up both the promises and pitfalls of this debate we're having now. In almost all of the technologies we're talking about, surveillance cameras, mass data surveillance for NSA screening, security screening, you can design the technologies in ways that protect privacy and security at the same time. It just takes legal constraints, technological will, and ultimately, Tim is right, a political commitment to insisting on the privacy protective technologies. And we'll see about NSA surveillance. I think the moment that some celebrity has their search terms revealed and leaked by accident, which is going to happen, there'll be an uproar and people are going to demand the whole thing
I
stop.
kind of disagree. I think we're in a moment, and I've even been surprised myself, where we're looking at what is reasonable, and maybe because people have been conditioned to through Facebook and Google, or maybe because someone's always has an uncle or an aunt who take pictures every 5 minutes and is filming everything, where people have sort of gotten used to this and don't find it so unreasonable, especially at a metadata level, And if that's the case, if the sort of metadata or stuff, not the particularized, but the more blobby type of information people feel okay with, then we may be seeing a changing moment in the Fourth Amendment. That's what I'm trying to suggest.
You might be right. I don't know what the answer is going to be. Let's have our second constitutional vote. Who in the room thinks that the telephone surveillance program, which sucks up your metadata, the telephone numbers and duration of your telephone calls without a warrant, violates the Fourth Amendment?
But they can't. You
They
have
can't
to
look
say
at
more.
it.
You can't say
Okay,
more.
you're right.
You have to say
They
more.
suck,
That's not fair.
they suck up the telephone numbers and the duration of the calls, and they can look at the number itself if an intelligence agent on his own say-so certifies that it's relevant to terrorism investigation.
Right, but no one does anything. It just sits. No human looks at it until there's some kind of suspicion.
Until the intelligence agent says that he thinks that it's
It's an
suspicious.
intelligence agent.
Yes, not a judge, not Congress. Exactly. Just the guy on his own saying I think it's suspicious. Who thinks that the program, as I've described it, violates the Fourth Amendment? And who thinks it is consistent with the Fourth Amendment? All right, this is Aspen, but another one from my team.
I don't know which side I think Aspen would be on, actually. What's interesting about privacy is it's not clear that it doesn't clearly go in partisan ways, many of these issues. I mean, the people who are really strong about this are on the far right or on the far left.
Of course, but the privacy side, which I think is my people here in this room, is a combination of civil libertarian liberals and libertarian conservatives. So Rand Paul and the ACLU are cheek to cheek on this, and I think that may be an Aspen sense.
Right, but what's interesting about the vote that just happened is it's inconsistent, I would say, with what the Supreme Court has said. So that vote suggests, and maybe it's the way you phrased it in this kind of friendly manner, and nice way, but the Supreme Court happens to think that the second group of people who put their hands up are right, at least for now, from precedent from the 70s, but that's at least where it is right now. That is the law.
That's true.
Now.
That's true.
Yeah.
And one other point that you guys might want to comment on is it's very difficult to get the Supreme Court to rule on these sorts of programs because the Supreme Court often finds that the program's secret and the party that's asserting that they are harmed has no evidence actually to show that surveillance was conducted on them. However, the ACLU just sued over the Prism program once they got details of this, and I'm curious what you guys think about that as a potential Supreme Court case where a party could say, look, there's been so much information collection that we know that information was collected from us and we have a privacy interest. Do you think that this is the sort of vehicle that might make it to a Supreme Court ruling that would get into this metadata question in a way that would update the Smith decision from the 60s?
That's a great question. You're absolutely right that the Supreme Court in the Clapper decision just in February dismissed an earlier ACLU suit to a surveillance program in which a group of academics and journalists and so forth said because they were calling abroad and because they knew that the calls abroad were being monitored, they were chilled in their association with potential clients and journalistic subjects and so forth. And the Supreme Court said because no individual journalist could prove for sure that he or she had been surveilled because the program was secret, therefore they had no standing to bring the case. And you're now asking, is this new program, in which case we know that domestic telephone conversations are certainly being surveilled, would that lead to a different standing result? I could well imagine at least some of the justices in the Clapper majority saying that because no particular individual knows that his or her metadata is actually being examined, because you need the certification by the intelligence agent before any human being could see it, that there's a similar standing problem here. I don't know whether the really fascinating standing debate, standing is a technical lawyer's term, and
right.
The words fascinating standing debate have been used about as frequently as Mike Kinsley used to say, worthwhile Canadian initiative. I hope I don't get into trouble for that equation. But
the thing with the Canadian thing, it's not that they're not
oh,
worthwhile.
sorry, you are Canadian. I'm
it's
so
not
sorry.
that not worthwhile.
See,
that was voted the
privacy
most
is
boring
over, get
headline,
over it.
actually, is what it was. It was voted the most boring headline.
Yes, that was
a
the
worthy Canadian initiative.
Yeah,
is voted
exactly.
the- It doesn't matter that it wasn't worthy. It's,
no,
it's
no,
not
it's the
interesting.
most boring. Yeah, that's right. So standing, Canada is not boring, but standing is usually boring, except this year when both the Proposition 8 marriage equality case and also the defensive marriage case turned in different ways on whether or not people had standing to sue. So I think the court, as we heard last night with Justice Kagan, is acutely aware of the significance of imposing these standing bars. And maybe the second time around, if Justice Kagan is right that the court's aware of what's going on in public debate, they'll be less likely to dismiss it.
But it does run into this issue because, again, it gets down to these laws about lines. And I've already talked about public and private and national and foreign. And the court, I think, is generally much less interested in getting involved in issues that have to do with basically with foreign policy.
Mm-hmm.
No Supreme Court wants to be in a position where they're saying, oh, we don't agree with your policy towards Iran and we're going to change it. And some of this stuff is foreign policy. Some of how the United States decides to survey enemies or terrorists is simply conduct of foreign policy. And the Supreme Court is on a tenuous ground when you have 9 justices trying to decide how we should conduct military or foreign policy.
One more this question I hope provokes more debate than the last one.
As opposed to the milquetoast exchange.
The milquetoast exchange we just had, yes.
What are we, chopped liver here?
A key difference between the NSA surveillance programs that are protected or held confidential under the Patriot Act and the surveillance camera paradigm we were talking about before is that people can look up and usually see the surveillance camera. They can't see the government collecting information in ways that are secret and can't be disclosed to them. Until the Obama administration, moved by the disclosures in these news reports last month, began to put out, I should say the NSA, began to put out information about privacy safeguards, which of course can't be confirmed. There really was almost no discussion of the program, first of all, and secondly of the safeguards. Would your views on this program be changed if there were a public set of safeguards that were issued, privacy safeguards, safeguards against secondary use of information, for example, if information about Americans' communication with an illegal gambling site or a copyright infringement site couldn't be used by the Department of Justice for other purposes, and if the privacy oversight was very clearly articulated? Could this become something that, Jeff, you wouldn't be so excited about, and Tim, that you would be warmer about?
The answer is yes, absolutely. That's what I said in the last exchange.
But bear in mind that fundamental to this is collecting information from people from communications from people who are not suspected of any illegal activity. That is the cornerstone of these NSA programs.
Well, that's, I suppose, the trickiest point. You can certainly design a program that focuses on suspected terrorists, that doesn't allow the government to share the information with law enforcement unless it finds evidence of terrorism, that has minimization requirements, that does not allow suspicionless people to be looked at. The question of whether, not that we trust the government, but I suppose whether we trust the technology and the legal constraints on it enough to allow suspicionless recording and amassing of masses of data, because we're confident that that data will only be examined by a human being if there's some kind of suspicion. turns on a degree of our faith in technology and our faith in the legal constraints.
Why do you say our faith in technology? You mean you think that it won't do what it's supposed to be doing? So you
It
think,
can't
for
be
example...
hacked. It can't be hacked, for example.
Oh, I see. Or you're saying that when you think the NSA thinks it's spying on foreigners, it might be spying on Americans. Is that your...
That's a separate
Right,
question, but just
right.
the broad question of whether we can tolerate
Right.
mass data valence with the promise that no human being will examine the data without a degree of individualized suspicion. Look, you know more about the
Right.
technology and hackability of this
Right.
than I do. Would you be confident that that would actually remain lockbox?
Well, unfortunately, I do know more about it, and it does make me... Things tend to come out now and then, and so that is always something that I think government does need to be very careful about in these areas, even when we have this situation. I think it's a really interesting question as to whether you care if a robot is reading your stuff. It's just like the fundamental underlying thing is, when do you care? And this is something that's come up for all this NSA stuff, is who do you care about reading? And it goes back to my friend Rex at the bar, who only cares if his girlfriend sees his stuff. He doesn't care about government, doesn't care about Google. And people have very different sensitivities. Some people...
Well, Tim, think about all the people here who use Gmail.
Right.
A robot is reading all of your Gmail
Exactly.
emails to produce advertising. How many people are upset about that and would make you be unwilling to use? How many people who currently use Gmail, now that you've really reflected on this, are going to switch to another email service provider?
It's just so good. You get so much stuff. It's like
So cool.
it's a classic.
Yeah.
It's not cool. But
Sorry, go ahead.
You're right. It's uncool to say it's cool.
no, there's this really interesting question at the heart of it that I think we're examining now: is who do we care about reading your stuff? Is it, because as I said, robots read them all the time, and probably Google employees could, when they want to, sort of just glance over and see what's going on. I mean, I don't know enough about the internal workings of Google. They don't usually want to. They don't care, but they do. Government, and then you have these sort of foreign, these intelligence officials. And in some ways, an intelligence official, I mean, why do they only care if you're interested in terrorism. Generally speaking, they're interested in terrorism links. So maybe you don't really care if the government is reading all your stuff, because they don't care about anything you think salacious. They just care about whether you're contacting foreign elements. And maybe you do care. I just think it's a really interesting debate as to who you really care read your stuff. And in fact, one of the amazing things in America is that most Americans let the worst person of all to read your stuff is probably your employer. Yeah, that's where Americans have the least privacy. I mean, the real problem, to sort of change a little bit, I mean, one of the real funny things in America is Americans are often very suspicious of government. The government doesn't do that much with your information, while your employer has a lot more of your information and actually will do things like fire you or demote you based on watching too much ESPN or something. So, or just even maybe arbitrary things that they just don't like your political tastes or something. So the real, often it's less government, which is trying to prevent terrorism, and the real problem I often think is with employers who know everything their employees are doing and may fire them for arbitrary and evil reasons.
Just one more beat on do we care if the robot reads our stuff, which is a fundamental question. You said when you know about the surveillance, it's fine, but when it's trying
no, I was asking if it made
yes,
a difference.
It doesn't make a difference.
Whether it makes
So
sense.
I think my strong sense is it's the uncertainty about whether or not we're being observed that is the core inhibitor of freedom, spontaneity, individuality, and eccentricity. This was the whole point of Bentham's panopticon, of course. You know the famous inspection tower where the guards would be concealed behind Venetian blinds. They could always see the inmates who were in cells pierced by light with windows that are open on both sides. So the guards can always see the inmates, and the inmates never know whether the guards are watching them. And it's the uncertainty about whether you're being observed that leads to an end of antisocial behavior. And I'll give just one example.
Can I just say that it's also the motives of the observer? So in the panopticon, you have prison guards, and you have sort of a maliciously intended person. And the question is, and people have very different instincts about government, but the question is whether you think we're thinking more of like Nixon administration style government, or we're thinking of sort of more benign, terrorist-focused government.
I don't know, because it's the uncertainty makes you not trust the motives of the government either. So when I was in London writing about the surveillance cameras, I'd been looking at surveillance cameras all day, and then I went to the theater and was having a drink with some friends outside a pub, and this guy came up and said, "Do you want to buy some Charlie?" And I didn't know what Charlie was, but I thought it sounded really, really bad. And I said, "No Charlie for me, be gone with you, I will never have Charlie." I was flamboyantly acting out this ridiculous impersonation of someone rejecting Charlie. Now, I later found out Charlie is some kind of drug, very, very bad, never use Charlie, ladies and gentlemen. But I wondered, why did I act in this sort of flamboyant way, and it was clearly because there was a camera across the street, and I'd been tuned to looking at the cameras all day, and this was one of the cameras. There are two kinds in Britain. Some follow you as you move, but some have opaque globes, because they're based on the Benthamite philosophy that being unsure about whether the camera is on will make you behave better. And I think obviously I had this on the brain, but I was internalizing the uncertainty of the camera and acting out my innocence in this flamboyant way. And that's why I think trust the government as a motive for making us being free is not helpful. And the fact that you just said that the stuff could leak makes me even more uncomfortable.
I'm just talking about the motives of the observers matter a lot. And you're very focused on government, and I'm saying employers are usually much more, they have good reasons too. They obviously don't want to do this. But some of the other actors are a lot more of a concern than anti-terrorism officials.
Let me say one more thing about the motives of the watchers, because I was in the control room at 3 in the morning in the digital city of Hull, which has wired itself up with more surveillance cameras than any other place in Britain. And I sat there watching the guys with joysticks kind of zoom in on people in the street. What do you think a bunch of bored, unsupervised guys at 3 in the morning with a joystick do with their cameras? They were pointing them at attractive teenagers making out. They're saying, oh, you're going to have to do a piece about how reserved the British are. They were following escorts, who were walking up and down the streets and commenting on their physical appearances, and they were tracking young men with dark skin. And it's not brain surgery. This is what leads to, unsupervised surveillance can lead to this sort of discriminatory activity, and the idea that the systems are ever going to avoid this is not something I have confidence
But can audit trails, can technology itself provide, with oversight by an inspector general, provide some protection against those sorts of abuse?
3 guys, a lot of coffee cups, some beer bottles. this is the way police work operates.
But this is a trade-off. This is the trade-off of contemporary living. I mean, we just live in an era where we are in a much more fragmented society and therefore face different types of threats. And I've said over and over, I'm returning my thesis, this is why there's this phrase, get a room. In other words, like when you're in the public, you're going to be, and you're making out in public, there is a risk this is going to become known. And I think, again, we have to figure out what that border is, but to say, there can't be that border and everything's sort of fuzzily privacy defined just gives up too much from what we need to do in these times.
We are out of time, so last word to Jeff.
I just wonder whether we even need these public cameras. In an age when, in Boston, thousands of feeds were voluntarily surrendered by private cameras. Justice Brandeis, my hero, the great hero of privacy, was very big on the curse of bigness and the importance of individual laboratories of democracy. I think the idea of top-down CCTV cameras is 20th century technology, and if we are to have surveillance, maybe it is best to come from private individuals rather than the government.
On that note, thank you both for a really provocative discussion.